Major breaking news. The Pam Bondi Donald Trump Department of Justice has just requested an additional approximately 30 days of time to make a decision whether or not they're going to seek cert from the United States Supreme Court in the Brian Range versus Merrick Garland case, dealing with federal gun control law 18 U.S.C. 922 G1, dealing with felons in possession of firearms. Let's talk about what's happening, what I think's going on here, and what's going to happen when we come right back. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in 2025 at the Gundies Awards. Thank you for your support. I really do appreciate all those out there who showed your support in favor of the Four Box of Diner channel. Okay, we have major breaking news. The Attorney General Pam Bondi and her lawyers at the Department of Justice have just filed an application or a motion with the United States Supreme Court asking for approximately another 30 days to make a decision as to whether or not they're going to seek cert in the Brian Range versus Merrick Garland case, which presumably is now Brian Range versus Pam Bondi, because she would be swapped out as the Attorney General in the caption of that case. Now, just a reminder, I'm going to tell you what the Brian Range case was about, what the Third Circuit held, and then why I think the Department of Justice might be seeking 30 days here. I don't think it's necessarily bad news at all, but I want to give you the information so you can make your own choices as the smartest person in the room. Just as a reminder, there is a series of fights going on across this country as to the applicability and constitutionality of federal gun control law 18 U.S.C. 922 G1, which is a part of the prohibited person statute. 922 G1 says that if you've been convicted of a felony, as defined by federal law, which could include misdemeanors under state law in some instances, if you've been convicted of a felony under federal law, you lose your gun rights for the rest of your life. Under 18 U.S.C. 922 G1, it is called the felon in possession statute. Brian Range was convicted of a state misdemeanor about 25 or 30 years ago involving alleged food stamp fraud or something along those lines. No evidence of violence, no evidence of danger, nothing like that for decades at all. He sued in Pennsylvania to get his Second Amendment rights back, saying that the law 922 G1 was unconstitutional as applied to him. This is an as applied challenge, not a facial challenge. It's as applied to him. He said that this law is unconstitutional because he is not a violent danger. In bringing this lawsuit during the litigation, Brian Range, who again has no evidence of violence, danger, or anything like that in his past, relied in large part originally on the dissent in the case of Cantor versus Barr, that Seventh Circuit decision where then Judge Amy Coney Barrett dissented and argued in her dissent in Cantor versus Barr that individuals that have been convicted of nonviolent felonies who have never shown any evidence of violence or danger to others, they cannot be disarmed for the rest of their lives under the Second Amendment. This decision in favor of the Second Amendment helped her get elevated from being a Seventh Circuit judge to the U.S. Supreme Court. That dissent by now Justice Amy Coney Barrett in favor of the Second Amendment gave rise to a lot of other litigation and scholarship and analysis by many federal courts, including but not limited to, most recently, the United States Court of Appeals for the Third Circuit covering Pennsylvania, New Jersey, and Delaware, in an en banc decision, which means that every active judge in the Third Circuit issued this decision or participated in a powerful opinion by Judge Thomas Hardiman, who could have been on the U.S. Supreme Court, by the way, didn't make it, but could have made it. It was very close. Judge Hardiman wrote a powerful decision explaining that indeed Brian Range could not be disarmed for the rest of his life by virtue of that several decade-old misdemeanor conviction of, welfare-related fraud in Pennsylvania those many decades ago. This meant that the federal gun control law was deemed or declared in part unconstitutional under the Second Amendment as applied to Brian Range. Now, in the normal course, A typical anti-gun administration would seek cert from the Supreme Court trying to overturn this, and a typical law and order Republican administration like a George H.W. Bush would seek cert, also trying to overturn the decision by the Third Circuit. But the Trump administration is both more pro-Second Amendment than those groups and a bit more savvy. So they have obviously decided to buy more time to decide whether or not they're going to seek cert from the United States Supreme Court to have the Supreme Court arguably overturn the pro-Second Amendment ruling, or perhaps they've decided, or they may decide, not to seek cert at all and just allow this ruling in favor of the Second Amendment to stand. So here's what I'm going to do now. I'm going to tell you why I think the Pam Bondi Attorney General's Office's Department of Justice may be buying more time. And then I'm going to tell you exactly what, if I were advising Attorney General Pam Bondi and the Department of Justice, exactly what my advice would be. But before we get to that, let's just go through some of the reasonable reasons. And I don't think this is bad news, by the way, this extension. I don't think it's bad news in and of itself. Let me tell you some of the reasons why they may have decided to buy more time. Number one, and I think this is probably the real reason, if I had to guess. The lawyer who is responsible for handling cases on behalf of the federal government before the United States before the U.S. Supreme Court, I should say, is the Solicitor General of the United States. As we stand here right now, Donald Trump's nominee to be the Solicitor General of the United States, John Sauer, has already had his hearing, but he has not been voted on and confirmed by the United States Senate, which means that you have a very competent acting Solicitor General, former Clarence Thomas clerk, by the name of Sarah Harris, who is the acting Solicitor General. Now, because the question of whether or not to seek cert in the Range case has wide-ranging implications, potentially on the Second Amendment and a lot of other issues involving federal law, it's quite possible that acting Solicitor General Sarah Harris, who's only doing this job until John Sauer is confirmed, which will occur at some point in the next month, I suspect. She may be waiting for the actual Solicitor General to be confirmed by the U.S. Senate and let him make the judgment call on this sort of close call. I suspect that's what's going on here, because this is one of these big cases and big decisions that the acting Solicitor General may say, let's just give it a few more weeks and let the actual Solicitor General make the decision after he's confirmed, because he's almost certainly going to get confirmed, and that's just a matter of time before the U.S. Senate actually votes for John Sauer and confirms him. I suspect that's what's really going on here. Okay, but beyond that, let me give you a couple other theories as to what might be happening. Now, this is Mark speculating. I'm guessing here. I don't have any inside information. I'm telling you what I think might be happening potentially. The second thing is, it's possible that the Trump administration, Department of Justice, wants to wait to see if there's a decision involving Snope, the AR-15 ban case out of Maryland, the semi-automatic rifle ban case out of Maryland, that's Snope, or the Ocean State tactical case. It's possible they may wait to see in the next 30 days if the Supreme Court will issue a ruling, either a per curiam in favor of the Second Amendment or a denial of cert with a dissent by, let's say, Clarence Thomas or Justice Alito. If that were to occur, the Department of Justice might be looking carefully at that decision, in particular the language of the dissent by, let's say, a Justice Thomas or Justice Alito, if that occurs, to try to get guidance as to whether or not it makes sense to seek cert in the Brian Range case. Because I'm pretty sure the Trump administration doesn't want to seek cert in the Brian Range case if they believe close to a fact, if they truly believe that the Second Amendment is going to lose the Brian Range case in front of the Supreme Court, then they probably will not seek cert. So they may be trying to judge to what degree they think they can trust the Supreme Court to get it right in the Brian Range case. The other possibility is they just may need more time. Remember, as I explained to you in another video, remember how I tell you that all these legal cases involving things other than the Second Amendment touch his fingers with the Second Amendment? And I want you to understand all that. All those cases you're seeing involving the federal government fighting over who gets to control USAID, the Inspector General, privilege issues, FOIA issues involving whether or not Donald Trump as president can take away top secret clearance from law firms that have been involved in things that he thinks are shenanigans related or whatever it is he's decided. It's quite possible that the Solicitor General's office is overwhelmed with work. And if my guess is, and this is what I'm hearing, I'm guessing it's true, that the White House lawyers in the White House counsel's office, as well as the Solicitor General's lawyers and all these other lawyers, are super duper duper busy working until, burning the midnight oil, trying to handle all these cases against Donald Trump and the Department of Justice and the federal government. Which means that the exact same lawyers that would have to write the cert petition to the U.S. Supreme Court may just be too busy. I can tell you, as a private practicing lawyer, if I had like a month-long trial coming up, and I'm like, look, I have a month-long trial. I need a month extension to submit my appellate brief because I'm going to be out of the office in trial. Things like that do happen, and I could easily see the Department of Justice lawyers saying, we're so swamped with all these crazy cases by these anti-Trump groups suing the federal government, we just don't have the lawyer bandwidth necessary to get the brief done in a high-quality fashion in the time allotted. Let's just give ourselves another 30 days. I think that's also quite a possibility. Now, the last possibility as to why they might not seek cert, they probably would not seek cert if they thought they were going to get an anti-Second Amendment ruling, or if they thought maybe they were going to resolve some of these issues involving nonviolent felons through the administrative process, which alludes to or references that New York Times article I previously did a video on, that there appears to be a movement within the White House, within the Department of Justice, about restoring rights under federal law in various ways, and maybe they've decided to do something administratively as opposed through the court system. Now, that is what may be going on. Okay, these are all very high-level, smart reasons that may really be going on in the real world, and just attacking Pam Bondi or attacking Donald Trump, I don't think any of that's A, productive or true. Again, it may turn out that they all turn out to be terrible, and if they all turn out to be terrible, I'll tell you so, but certainly I don't think any of that's happening right here and right now. Now, let me tell you what should happen. If I were sitting down with Attorney General Pam Bondi and President Trump and the team, Sarah Harris or John Sauer right here, let me tell you exactly what I would say. Okay, here's what I would say. You need to pull a Windsor. You need to learn and do what Barack Obama's Department of Justice did with Eric Holder in the Windsor case dealing with gay couples, gay marriage. In the Windsor case, I'm going to tell you what happened in Windsor, and then I'm going to apply that precedent to what should occur in the Bryan Range case right here and right now. In the Windsor case, that involved, as I recall, a gay couple, maybe multiple gay couples, that were trying to claim various federal tax deductions on their taxes, okay? And the federal government took the position in the lower courts that, no, you're not married in the eyes of the federal government under the Defense of Marriage Act, things like this, and therefore we're not going to give you the tax deduction that a married couple would be entitled to. The lower courts, listen carefully, the lower courts ruled against the gay couples and in favor of the federal government and in favor of the Defense Against Marriage Act, or Defense of Marriage Act, okay? Now, after the Court of Appeals ruled against the gay couples, Barack Obama, who supported gay marriage and the gay couples, was in charge of the Department of Justice and the federal government and federal law. So what happened was this, listen carefully. The Barack Obama Department of Justice sought cert in the Windsor case, and they argued to the United States Supreme Court the following. They says, you need to take the Windsor case and decide whether or not, under the Constitution and so on, we have to treat gay couples the same as married couples for the purposes of the federal tax code. So, and then they go on to say, we at the federal government are going to continue to enforce this law against gay couples and deny them their tax deductions, which means that you're going to still have standing. And why is that important? Because what about to say? What the Obama Department of Justice did is they sought cert, saying that you need to take this case. They then say that there's standing and there is an active case in controversy under Article 3 of the U.S. Constitution, which you have to get into federal court and stay in federal court. And they said, because we're going to continue to enforce this law, there is an ongoing case or controversy. There's an actual law that's being enforced, and the plaintiffs, the gay couples, are being injured. So therefore they have standing. Then the Supreme Court granted cert in the Windsor case and heard the case. After the Supreme Court granted cert, the Barack Obama Department of Justice switched sides and said, even though we're going to continue to enforce the law to make sure everyone has standing, we believe at the Department of Justice that the gay couples are correct on the constitutional question, and we are going to urge the U.S. Supreme Court to rule in favor of the gay couples in the Windsor case, even though we're going to continue to enforce the law against gay couples until the Supreme Court overturns it. And that's exactly what happened. The Supreme Court said there was standing because the Obama administration was enforcing this law against gay couples, so you had standing, you had an actual case in controversy, which you need under Article 3 of the U.S. Constitution for courts to have standing in the federal system. And then the court ruled in favor of the gay couples, knocking out that aspect of the Defense of Marriage Act and said it was unconstitutional. Now, with that precedent in mind, that notion, that precedent I just articulated must be applied, in my opinion, by the Trump administration in the Brian Range case. What does that mean? It means that what the Trump administration Solicitor General should do when John Sauer is confirmed, which I presume will be in the next few weeks. They know the schedule better than I do. I don't know the schedule in the U.S. Senate as to when they're going to have a vote on this. But assuming they're going to get John Sauer in the slot of the Solicitor General itself, not acting, but the actual Solicitor General, he should, number one, seek cert to the United States Supreme Court to say, look, a federal law, 18 U.S.C. 922 G1, has been in part declared unconstitutional by a federal court. That needs to be resolved because we in the Department of Justice are going to continue to enforce federal gun control law 18 U.S.C. 922 G1 against everyone. So if we catch you, a nonviolent felon with a gun somewhere in this country, we're going to try to put you in prison, which means you're going to continue to have a standing. You're still going to have standing because you're still enforcing the law against American citizens. And you also have a case or controversy because the Department of Justice can say we're going to continue to enforce that federal gun control law. Then, if the Supreme Court, and they should, grants cert, and remember, the Department of Justice is the one that has to seek cert in this case because they're the ones that lost the Brian Range case. Brian Range's lawyers cannot seek cert because they won the case. There's nothing for them to appeal from, right? They've won, so it has to be the Pam Bondi Department of Justice. And John Sauer, the Solicitor General, should seek cert in Brian Range, at the same time telling the Supreme Court they're going to continue to enforce the law, so you keep that standing thing going, you keep the case in controversy going, and then when the Supreme Court, listen carefully, when the Supreme Court grants cert in the Range case, which I think they almost certainly will do so if the Solicitor General seeks cert, at that point, a Windsor will be pulled by the Department of Justice under Donald Trump and Pam Bondi, and they will flip sides and they will argue to the Supreme Court on the merits that they agree that Brian Range cannot be disarmed for a multi-decade-old misdemeanor conviction that has nothing to do with violence in Pennsylvania, and therefore that should be affirmed, that the Department of Justice under Pam Bondi should argue that the Third Circuit ruling should be affirmed and that 922 G1 should indeed be declared unconstitutional as applied to Brian Range and people like Brian Range where there's no evidence of violence or danger at all. And that would also be consistent with Rahimi. Now, to make you the smartest person in the room, I'm going to add on to that. There is no way the Department of Justice is going to be able to dodge this issue forever because there is a 10th Circuit decision, I believe it's called Vincent, Melinda Vincent out of the 10th Circuit. I think that was out of Colorado. Same idea. She was convicted of writing a bad check at a grocery store many, many, many years ago, maybe decades ago, and she lost her attempt to get her gun rights back in the 10th Circuit. So even if the Trump administration thinks they're going to dodge this metaphorical bullet in the Range case and avoid that from going to the U.S. Supreme Court, the Supreme Court's likely going to grant cert in the Vincent case because you're going to have a circuit split where the 10th Circuit says 922 G1 is constitutional as applied to nonviolent felons like Melinda Vincent. On the other hand, you have the opposite result by the Judge Thomas Hardiman decision in Range. So you now have a circuit split between the 10th Circuit in Vincent and the Third Circuit in Range, and now you have a circuit split. So even if Pam Bondi and John Sauer don't seek cert in Range, the Supreme Court is almost certainly still going to have to deal with this issue, except the mechanism will be the Melinda Vincent case out of the 10th Circuit because you're going to have a circuit split. So in light of that, the right answer is DOJ should seek cert Paula Windsor in the Range case because whatever they do in range, they're going to have to deal with the same concept in Vincent. And I don't see how the Supreme Court won't take this case, given the fact you have a circuit split. And again, DOJ cannot prevent the petition for cert being sought by the lawyers for Melinda Vincent, because Melinda Vincent lost the case and she gets to control whether or not they seek cert in the 10th Circuit. So Bondi can control the 3rd Circuit, a petition for cert decision. I should say John Sauer, Solicitor General, can control it in the 3rd Circuit, but they can't control it in the 10th. That will be controlled by the private attorney, presumably, for Melinda Vincent. So there you have it. In my view, I think the Trump administration should seek cert in the range case and do a Windsor. That to me is the no-brainer. But again, maybe you all think I'm wrong. Maybe somebody thinks I'm wrong. Maybe the Trump administration knows something that I don't know, which would alter my reasoning. But that's how I see it right here and right now. So there you have it, folks. Hope you learned something here today. Make sure you follow me on X at For a Box of Diner. Don't forget to subscribe, both YouTube and Rumble, trying to get to 200,000 subscribers on YouTube. And I look forward to talking to all of you very, very soon here at the For a Box of Diner.
Orders up. Table 2A.